But we have to hear 3 more students. The first of whom is Mr. Michael Charles, or some of you call him Charles Michael. Michael's topic today is, should the state regulate the manner in which parents are allowed to discipline their children? Let's welcome Mr. Michael Charles.
Spare the rod and spoil the child. Many scholars have posited, contrary to this popular saying, that physical punishment does no good and in fact causes harm to the child. In response to these studies, however, researchers have noted that these studies are often based on cases of excessive violence, and in fact, the children whose parents fail to use the rod are the ones who are harmed. But whose responsibility is it to say whether the rod is the best form of punishment? Whose responsibility is it to state how many rods are needed for a particular offense? Coming on the heels of several reports of excessive discipline within the home, many cries have been made for regulation of punishment within the home. While those lobbying for such state intervention have very noble intentions, it is submitted that it is unreasonable, unjust, unnecessary, and impractical to do so locally. Who has the primary responsibility to discipline children? Parents, reasonably so. They brought them into the world, they know them best, and they are in the position to state what form of punishment is required for a particular offense. Contrary to what you may think, I did some very mischievous things as a child. My parents did not have any form of regulations telling them how to discipline me. They, however, used their tact and disciplined me according to my age, my capacity, and the offense that I committed. At times, that meant a little licks, but I did not die. And, in fact, the discipline that my parents used made me the man that I am today. And I'm sure that many of you can agree with that. Further, state regulation in this matter directly contravenes parental rights and privacy of the home. Article 17.1 of the United Nations International Covenant on Civil and Political Rights states, "No one shall be subjected to arbitrary interference with his privacy, family, or home." That right is further enshrined in Section 4 of our Constitution. Protected by this provision is the right to administer discipline. Interestingly, the majority of parents exercise this right while respecting the rights of the child not to be subjected to torture, cruel, inhuman, or degrading treatment. Of course, rights can be limited where it is reasonably required to do so. What is the goal in state regulation of discipline? No doubt it is to deter parents from using excessive forms of discipline, to punish parents who do, and ultimately to protect the children. Don't we have existing legislation that does this? Laws including the Children Act, Domestic Violence Act, and Summary Offences Act complement each other and provide a robust mechanism whereby Trinidad respects the obligations under the United Nations Convention on the Rights of the Child. Article 37 of that convention states that parties shall ensure that no child shall be subjected to torture or other cruel, inhuman, or degrading treatment or punishment. Consider one of our acts, the Children Amendment Act in Section 22. It specifically allows parents to administer reasonable discipline. There is therefore no need for legislation that specifically regulates the manner in which parents exercise these rights, where provisions are already in place that deal with parents who overstep these boundaries. Finally, it is impractical to do so locally. No one form of punishment suits each offense. Different forms of punishment are effective on different children and in different circumstances. And if drafting the regulations isn't problematic enough, consider the impracticality that is placed with monitoring and enforcing these regulations. States like New Zealand have completely prohibited physical punishment. New South Wales has even limited where punishment can be applied on the child's body. Other states like Australia have taken a less restrictive approach and stated that reasonable chastisement is allowed, having regard to the offense, the age, and capacity of the child. But, and these factors that parents already take into consideration when disciplining their children. So it is restated that such intervention by the states is unreasonable, unjust, unnecessary, and impractical in our local context. Rather than using our already limited resources to create more regulation, what we should be doing is educating parents so that they do not overstep these boundaries, and further, we should be putting effort in enforcing the existing legislation that deals with parents who cross the reasonable threshold and enter the realm of cruel, inhuman, and degrading treatment. I thank you.